May 20th, 2020, 5/20/2020, I guess. In spirit of all things with coronavirus and people the coming out back into society, let's say, maybe there's lots of talk of a round 2 or round 3 of this virus. Who knows, and hope to God not. But we thought we'd share a conversation with a lot of folks on 5 critical estate planning documents for people to have during times like this to protect your money, to protect your family, to protect your property. So Glenn, to kind of tee it off, I thought I would ask you about one of the common documents, a healthcare power of attorney. There's multiple powers of attorney, but to start off on healthcare power of attorney, do me a favor. I'm not the most legal expert on those documents. Can you tell me in your words, what is a healthcare power of attorney? And then where would I ever use something like that at?
Okay, absolutely. So let's start with the why would you need one? And, you know, imagine yourself, you know, you have a stroke or, you know, something, you're incapacitated and in a hospital and you're unable to make decisions for yourself regarding healthcare. That's when this document comes into play. Doctors and health professionals are going to look to you to make your own healthcare decisions as long as you're able to. But if you're unable to do so, you want to make sure that you've appointed somebody else to be able to make those important decisions for you about your healthcare, all that. So a healthcare power of attorney is the document where you appoint that individual or individuals that you would want making those decisions for you. So kind of your healthcare advocate that's going to make decisions for you. Here's what I see. Most people name one person, right? They'll name their spouse as their primary if they've got a spouse, and then one of their children afterwards, and they'll name one at a time. And there's nothing wrong with doing that. I mean, who do you want making healthcare decisions for you? But I always tell people, think about, you know, what if we name more than one person? We name multiple people, you know, your spouse and all your kids, all those co-agents, anyone who can act independently. And the reason I tell people think about that is there's various reasons. One, we don't have to pick favorites, right? We're choosing one. Two, it can be a really good idea to have multiple boots on the ground. If we become incapacitated, oftentimes that's a prolonged period of time, right? We may have a long period of time. If we have dementia, Alzheimer's, we've had a stroke where we're unable to make healthcare decisions, putting that burden on one person to have to be the one that always is, you know, if they're still working, taking off work to get you to doctor's appointments, to meet with Dr. Like, so where you have multiple people can make the decision. Also can happen quicker, where somebody can quickly, any one of them can make that. So as long as you got a family dynamics where everybody gets along well, I think it's, you know, at least worthy of consideration whether we should have multiple people or multiple boots on the ground as we appoint as our agent. But you appoint somebody to trust. And the other thing with that document, you want to give them enough direction that they, you know, they know what to do and avoid fighting. So, and I know that's something big with you, Mark, is whenever we do the planning, you know, trying to avoid family fighting.
Right. Okay, so obviously, if you're married, you want to put your spouse as your primary power of attorney, of course, and then you kind of list a backup. Have you ever experienced an issue where, let's say you have multiple backups, let's say you list 2 or 3 kids down as powers of attorney for the backup, but they have to step in. Maybe mom's not available, something, but the kids have to step in. Have you ever seen a problem where you get kids who can't agree upon things? So is it good to have multiple backups with equal responsibilities, or how do you phrase it in a power of attorney so that if you do list multiple kids, there's not going to be the conflict of, well, I think this is better for dad, I think this is better for dad?
So that's one of the considerations we have to go through when we're naming multiple people. And so we really look at the family dynamics. Here's been my experience for doing this over, you know, a long period of time, is that typically your routine medical decisions, the things that are covered by your healthcare power of attorney, are not ones that create a lot of conflict, especially if we've had that family meeting, we've talked about what our needs are. Most of the time, you know, your kids or loved ones that you've appointed, they're looking to the medical professionals to give guidance what the decision is, and our medical professionals just need somebody to be able to authorize it and okay it. This is not the document where we're going to address those issues where we can have a lot of conflict, where you see end-of-life decisions. We're going to talk about that one a little bit later. But that's one that I'm very passionate about, and pound on the table and say, let's make sure we make those decisions knowing of what we want. So it is a consideration. If you have family that there tends to be some friction, then I think naming multiple people may not be a good idea. And so, we can put provisions in of what happens if there's conflict, but we have to think that through too a little bit too, because there can be so that creates some uncertainty for the healthcare provider. Well, how do I know there's not conflict? And so now I've got to get everybody to authorize. So generally we don't like to do that route. If you're comfortable with it, like in my case, my wife, my 3 children, and their spouses are all named as co. Anyone, I trust them all completely. They get along fantastic. And that's what happened with my mom. My mom had a prolonged stay in the hospital at the end of her life. And my dad and myself and my 2 brothers and my wife were all co-agents. And it worked out so well to have multiple people. None of us could be there around the clock. But between us as a family unit, we pretty well had that covered. And when the doctors came in, we could make those decisions.
Well, that's a healthcare power of attorney. There's another power of attorney out there that's called it's a financial power of attorney.
Right. Yeah. So financial power of attorney, I'm sure you deal with these a lot in your profession. So kind of let me ask you that in your industry, if you have a client that provides you with a financial power of attorney, what's that like? And what's it like if they don't have a power of attorney? I'm sure you've got stories that kind of relate to both of those scenarios.
Well, on a financial power of attorney, what I found is when clients give those to us in advance, life is better. We keep it on file with us and we don't need to use it. And hopefully we're not going to use it for a long time, and maybe we'll never use it. But there has been times where something has happened with my client and that power of attorney needs to kick in, and we can go to bat and actually talk to the spouse about the other spouse's assets, or we can actually talk to the kids about mom and dad's assets, because mom and dad are my clients. Without that power of attorney, I really can't talk to them. Now, if I have a long-standing relationship with that client and I know their kids and I've talked with the kids, with the parents, it's probably not a big deal because we've already got consent to talk to them. Where it's a big deal is being an independent financial advisor. We work with tons of companies, insurance companies, banking companies, investment companies, and we have to provide that power of attorney document to them because they need to be able to release the information to that other person. So I've had situations where mom and dad, let's say, we're doing fine. They maybe didn't have an estate plan. There was no power of attorney at all. And dad went into a nursing home. He had a stroke. Alive, not doing great, but there's things that need to be done, bills that need to be paid, things that happen. And the wife couldn't step in and do some of those things. It was one of those, she literally had to go to court, get a lawyer, go to court, and create these documents while her husband was alive, but incapacitated, not able to take care of things, just so that she can come in and prove I'm his wife and I need to take care of paying these bills. I've seen that same thing with kids. One parent's already gone and I'm working with the surviving parent. I've been working with that surviving parent for years. And then the kids come in and help out. So I've seen that a lot, but I've also seen some bad stories with powers of attorney. And I was just going to throw that back on you so we have a healthcare power of attorney, we have a financial power of attorney, and they're both like super important. But have you ever seen one, Glenn, where somebody has gotten a power of attorney, they only got one, but they didn't get both?
Absolutely. I mean, I've been doing those on, I've seen about all of it. Yes, you run into, and the most common is they have a healthcare power of attorney, but they don't have the financial. It can be the other way around, but most commonly, they've got their healthcare documents because they needed it when they went into a doctor or something. What I would tell people with financial power of attorney, now this is one where I think, now let's think long and hard if we're going to put more than one person. What I have found typically one at a time works better with the financial power of attorney. Even when families get along, and it's not always, that they have disagreements on what to do. A lot of times it's like, wait, I thought you were doing that. I thought you were doing it. Things don't get done. So we can have more than one, but again, we just want to think through that process. When you're doing a power of attorney, this was true for healthcare and financial. And financial, you want to make sure that you appoint somebody you trust. And once you find that person, give them the power to do anything and everything they need to do to protect you, right? A lot of powers of attorneys, financial power of attorneys that are out there, they're really inadequate. You've got to think, what is the end game? When is this thing going to come into play? Well, it comes into play primarily when you're incapacitated and can't make decisions for yourself. And so we want to make sure that we've got the ability to, enter into estate planning for you, create trust, do asset protection planning for you, make decisions to save money from the spin down if we have to go into nursing care, if we've had mention things. So give the people you trust the power to do what they need. And my other strong recommendation to people is to at least consider, because most powers of attorneys I see, people bring up powers of attorneys they've had drafted up somewhere else. Those powers of attorneys usually say, effective upon my incapacity is determined by 2 licensed physicians in writing, at least one of whom is my primary care physician, something along those lines. It takes 2 doctors to certify in writing that you're incapacitated. What's the problem with that? We've had a crisis. You've had a stroke or something. You're unable to make financial decisions for yourself. And whoever you've appointed as your agent, they're stuck. They can't do anything until you've been examined by 2 doctors and they get around to writing their letters. And sometimes that takes 7, 8 weeks to get done. In the meantime, everything's frozen. So what I tell people is, if we're going to trust this person when we're incapacitated and don't know what the heck's going on, maybe we should trust them when we're alive and well, and just make it effective immediately. We don't even necessarily have to tell them it was effective immediately. We'd say, hey, we got a power of attorney. It's in my lockbox when you need it, have access. But if we're not comfortable with that, then what I tell people is, let's consider creating our own private disability panel. I'm incapacitated when my spouse and my 3 children unanimously agree, or the majority of them agree, whatever we want, but some mechanism by which we can move quickly. Because I think so many people and a lot of attorneys, we're not really thinking, how does this work at the end game? So those are some recommendations I'd have for the power of attorney. But both of those, healthcare and financial, very important documents for people to have in place, and what I would call critical documents. That is your incapacity plan.
My parents have a really good estate plan, as you know, and they've had it for a long time, but it's been outdated. And so I just want to tell you that from my parents' perspective and my perspective as their child, I'm so glad that you reevaluated their estate plan. I'm glad you enhanced it and updated it to the latest family dynamics as well as the latest law. So it's a big piece of mind as a child to my parents that I really appreciate all that you did for my parents on that. And I myself, and my wife, Amy, and we've had our estate plan done for a long time too. And obviously these were both done by attorneys way before we ever got to meet you. And it's peace of mind for Amy and I to know that our documents are in your hands. I know you're re-reviewing them and you're updating some things right now. So I can't wait to get my in-laws over to you guys, to you and Marion, so that you can help them get a good established estate plan. Because I think my in-laws probably just have some real basic documents that are very old, and it's time that we need to get those updated. So thank you for that. Let me, hold on, give me a second here. All right, I got 2 screens going here, and I want to make sure I didn't get one screen in my way. Hey, switching gears, because we want to talk about 5 documents. We talked about healthcare power of attorney and financial power of attorney. So can you give it to me in layman's terms? Because I'm a financial, let's say, nerd. I'm not necessarily good with the medical stuff, and I really don't have a lot of patience, I'll be honest, when it comes to the medical industry. And, I go to the doctor's office and I'm on time, but I'm sitting there 20 minutes waiting. I just struggle with the medical industry sometimes. But what's the difference between a healthcare power of attorney versus like a HIPAA release? Because every time I go to the doctor's office, I'm always signing one of those HIPAA releases, like every single appointment, I always have to sign one of those. But, I don't, be honest, I don't really read those because it's like 2 pages long and I have to read it and sign it before I get admitted in. So what's the difference between a healthcare power of attorney and a HIPAA release?
I'm probably the guy that's making them 20 minutes behind because I'm the guy that has to read every word. So, we've all heard of HIPAA, and so HIPAA the HIPAA laws were passed to protect our medical records and medical history, to keep it private and only authorize the release to people that we've authorized. And there are huge penalties for healthcare providers who violate that. We're still seeing it's a bit, unevenly applied. What I find is a lot of times I'll go into a hospital for a client who, to maybe get some documents signed. I'm told they're in room, 220. I go to room 220, it's empty. And I'm pretty sure they're still in the hospital somewhere. And the nurses, they won't even talk to me when I say, hey, did they move them to a different room? Because there's no HIPAA authorization. So I have to call the client or the kids and figure out where they're at. And I get into the room and I'm in there, and in walks a doctor and just starts spilling the beans with me in the room, and have been authorized. But your HIPAA authorization is where you authorize who can get that protected information. And again, you may name one person to be your healthcare agent who makes the decisions for you, but you may want all of your kids to be able to talk to the doctors and get medical reports. So it's just the person that you're authorizing. That's typically a separate document for anybody who's not an agent under the power of attorney. That HIPAA authorization is a separate document. Most of the hospitals and doctors are going to have their own form as well, because they want to make sure that they've got it in their files, and that way they can, if somebody calls in and wants the lab results or something, they can release it to them. So it's the document we do it. Here's what I want people to understand about this document. You assume that you can get that information about your spouse. You can't always do it. So we had a situation that happened during this whole COVID pandemic. Wife had a stroke. She was rushed to the hospital. Husband went to the hospital as well, but he got there. He wasn't allowed past the checkpoint. They had a checkpoint coming in with the whole COVID, and they said, you can't come in. You know, they were limiting the people that could come in. They told him, go home, and one of the social workers from the hospital would call him. They called him, and they asked for his wife's HIPAA authorization and healthcare power of attorney, and he told them, we never signed one. We haven't got around to doing it yet. And she told him, you're going to have to go hire an attorney. We can't even talk to you about your health situation. So that's when he reached our office. And the emotional turmoil and the emotional stress that was caused because that simple document had not been signed. So I tell people, you know, it's just one of those critical documents. We don't any of it. It's kind of a pain in the rear to sign those things all the time, but make sure you get those in place. And that's something we can certainly help people with if they don't have those documents. And with any of this, we can help. But you know, get those documents in place.
So, Glenn, I see that we have some questions that are coming in. And for folks that are sending us questions through Facebook and through Zoom, first off, thank you. Let us get through, if you don't mind, these 5 topics that we want to talk on that are critical documents. And based on time, if we get to those questions at the end, we definitely going to address those for you. If not, we're making note of those questions, and we're going to schedule a phone call, depending on what the question is, a phone call directly with me to get those questions answered. We'll schedule a phone call directly with you, with Attorney Glenn Stockton here on the phone, or maybe a Zoom or a phone call to help get those questions answered. So bear with us. We want to make sure we get through a couple more topics. Glenn, the next thing I think we wanted to hit on out of the 5 documents was a will. You know, what people just typically call a will, but I think the legal name is last will and testament.
These terms can be very confusing. You've got your will, your living will, a living trust, and what other things. So when we refer to the will, I like to use the word last will and testament to make sure that we're clarifying that it's separate. You know, this is your last will. This is your end of life. The answer is who gets what. Again, Mark, you've had situations, I'm sure, where the last will and testament, you know, people had one, but they didn't coordinate with their investment accounts, their beneficiary designations, because that's one thing people need to consider is we have the will. The will answers the who gets what question. That's what the purpose of that document is. But it is overridden for assets that have beneficiary designations on it. Those beneficiary designations are going to control. So in your industry, you had to have run across situations where those two things have been in conflict. So
thank goodness, at least in our office, we're very organized and let's call it anal retentive when we're doing paperwork. And then when we do reviews, we're literally having a process right now where once a year, we're asking clients throughout one of the reviews that we have, but at least once a year, we're asking, has there been any change in your family dynamics? Something that would cause us to need to change the beneficiary from before. Because people don't think about that. But yeah, I've seen a couple situations, Glenn, over my 24 years where the will says, I want to give everything 50-50 to my 2 kids. But then it also says, I want to incorporate maybe this charity or that charity to receive something. So charity gets this, and then everything else 50-50 to my 2 kids. Well, that's great. They went to an attorney, they had that stuff well thought out and put into writing into their will or their last will and testament. But their accounts with me said beneficiaries are 50-50 kids. And what they don't realize is a beneficiary document is more powerful than a will. So if their will says give 10% to charity and the remaining 90% is split 50-50 to the 2 kids, but my accounts, my IRAs, my 401ks, my Roth IRAs, life insurance, annuities, whatever that have beneficiaries on it, it says 50-50, that charity doesn't get anything. And so that's a perfect example of where I find clients, their will says one thing and it's well thought out with their attorney, but with their financial advisor being us or their other advisor that they had someplace else, didn't coordinate that. And a lot of times it's not asked. It's just beneficiary doesn't really matter to me as a financial advisor. It matters to you. So a lot of financial advisors just kind of skip past that really quickly. So I know we try to spend time on that because I've had situations where my client died and I'm dealing with the kids. And now there's like fighting amongst the kids. There's fighting with the kids with us because they're mad at us because the will says one thing and the beneficiaries say something else. And we have no liability here. We did it, the beneficiary is what the beneficiary is. So I've seen some of those problems. So a last will and testament has to be coordinated with your accounts.
Tell people it's a team sport. Your financial advisor and your attorney should be communicating. You got to make sure this stuff done. Where I see it come in most often is in second marriage situations where the problem. So the will, they're like, hey, I want to make sure that some of my assets get to my kids and my death, not to my new spouse necessarily. I want to make sure it get there. But then on their benefit, so that's what their will setup say. But then they've got a beneficiary designation, their IRA, and their spouse is the primary beneficiary. And now what happens? That's the new spouse's asset at your death. Your will has no government. And then at that spouse's death, it's 100% going to their beneficiaries. So a lot of times it's not even intentional. It's an accidental disinheritance because the way those beneficiary forms are done. So that's why I like to do an end review and say, guys, we got to be looking at this stuff and make sure we know how our assets are going to be distributed at the time of death. All right, we got.
A will doesn't protect our assets. A will just basically says, when I die, this is who I want to get certain assets. It spells out how it's distributed. But the problem is it just needs to be coordinated with your beneficiaries and your accounts. So switching gears then, since we're talking about a last will and testament, the last document we want to hit on is a living will. And I think people easily confuse the term will or a last will and testament and a living will. They kind of think that's all the same thing. So tell me in your words, what is a living will and when would somebody ever need a living will?
So living will, this is, I said earlier, this is something I'm very passionate about. The living will is basically the pull the plug document. This is the document where you specify what's going to happen in the life. This one does only come by law, only comes into effect when two doctors have certified either you're dying, there's nothing they can do to stop it. So you're terminal and there is no cure, you're going to die whether you get treatment or not. Or they certify you're in a persistent vegetative state. You're in a coma, you're never coming out of it. If two doctors certify that, the living will says, what do you want to happen? And the vast majority of people say, look, in that situation, I don't want you to keep me artificially alive to keep me for sake of keeping alive. Let me die, but let me die with dignity. Don't let me suffer. So no, don't keep me artificially alive, but give me comfort care, right? So pain medications, that thing. So give comfort care. And it's also the document where you're going to address, do you want feeding tubes? Do you want, artificially supplying hydration, nutrition, do those get removed? And everybody probably on here, or at least most of us will probably remember the Terry Schiavo situation. The young girl had been in an accident and on feeding tubes, and she didn't have one of these documents, and the husband had to go to court, and there was this huge family fight with the parents about the removal of feeding tubes. All of these documents, the state has a plan. If you don't get the planning done, there's things there. But the living will, I would just tell people, don't put that on your loved ones. Make that important decisions for yourself in advance in case we ever need it. We hope we never need it, but get it done and communicate it. So those are all critical documents. We may also need trusts and some things like that for people. Even where we have a trust, we still have a will. So those 5 documents we talked about today would be the ones I would say everybody should have these documents in place. And if you don't have them done, get them done. If you have them done and you haven't looked at them recently, pull them out and look at these things. Make sure they do what they need to do.
Well, Glenn, we're at our time. We're actually a little over 8:30. I have to run because I have another 8:30 meeting, and then I have a 9 and 9:30. I have to go back to back today. Hey, first off, great to see you. I want to say thank you again for the work that you've done for my family, the work that you've done for me. I want a huge thanks for all the work that you've done with tons of my clients. You're a great, trusted, strategic partner of ours, and just more importantly, you're a great friend. And I just want to say thank you for you and your wife Tamla and Marion and your whole staff, because you got a rock star staff. And I made you a little note. So
wait, let me.
Thank you so much for being with me here today. We'll do a community cafe again next week, same time, 8 o'clock next Wednesday. So thank you again, Glenn. Have a great rest of your day, bud.
Thank you, guys. Mark, Cindy, I appreciate it. Bye-bye.
Bye-bye.